Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gregg, and I'm a financial mediator and business valuation expert in St. Louis, Missouri. So today I have the pleasure of speaking with Scott Zucker. He's a lawyer and mediator in Atlanta, Georgia. He wrote a book called The Mediation Minute, and we're discussing a topic which I am very fond of. You know, my father's a psychologist, so I probably should cover that first. But beyond the legal argument and talking about the psychology of mediation, specifically in business or commercial mediation, which is where Scott primarily operates and has a base of understanding. So you all know that I talk a lot about divorce, but today we're also going to talk about business divorce mediation, which is a little bit different. So welcome, Scott. How are you today?
Well, thank you, Melissa. It's great to be with you and look forward to talking with you about these important and interesting topics.
Yeah, and normally we wait till the end to talk about like the book, but I want to just kind of plug it just a little bit, right? So, and maybe that'll give us a good entry way to know a little bit more about you, but what kind of got you as a lawyer to kind of move into mediation and then drew you to kind of write a book? Because again, you must have seen something happening in mediation that you thought you wanted to educate people about, right?
Yeah, that's very true. I've been a commercial litigator. I'm in my 39th year of practice. So I have been the trial guy and the mediation or the deposition guy and the motion guy for many, many decades. And I really became frustrated with the process of litigation. A lot of my cases were moved to mediation by the courts back in the 80s and 90s. So as that ADR process started to develop, I got more familiar with it as an advocate in the process. And then I realized that the best way out of this, as we were talking about broken system, is to push the mediation or alternative dispute resolution approach for my clients. And more, I was doing more and more mediations, learning more and more about it. Found myself writing more about it because I thought the topic was fascinating. And I've written a number of, I'd like to think, interesting articles about this issue. And at some point, I decided to just create the compilation of all those articles, those 15, 20 years of writing articles, and put them in the book. And hopefully can be a guidebook for other mediators or advocates out there to learn about mediation.
Well, and our primary focus today is to talk about like the impacts of mediation and how a business owner can really use it as a tool to, you know, deal with partner disputes, deal with vendor issues, deal with client issues, employee, you know, there's a lot of benefits to mediation. One of the things that I think people should be mindful of is it's about control. You know, so in mediation, there's going to be a lot of control dynamics, right, that are at play, but also you don't have as much control in the system as you maybe do in mediation, right? Exactly. And you have control over presenting your situation in a certain way and preparing for the mediation. And maybe we could start there because we encourage people to prep for mediation and not like an hour beforehand, like a couple weeks, you know, get your financial picture, get your evidence, like almost go to mediation like you were prepping for trial. So where are you on the spectrum of like encouraging business owners to be prepared or even, you know, prepping them in some capacity if somebody comes to you and's like, hey, how do I get ready for mediation? Like, what would you talk to a business owner about in that respect?
They're all great questions. You use the term control. I use the term self-determination in mediation. It's the only opportunity for parties in a dispute to control or resolve it based upon their own decision making. If they go to court, it's going to be left to a judge or jury, and they are completely out of control. There's no self once the matter is turned over to a judge or a jury to make a decision. And it can be very frustrating if you've lived with a problem to leave it to someone else's hands who may not ultimately understand it to then make a ruling about. The best person to reach a resolution of a dispute in a commercial context, or even certainly domestic, are the people that are involved themselves, the people that are suffering through it. So self-determination. To your question about preparation, it is essential. If you go into a mediation without knowing your numbers, your damages, a calculation of your goals with respect to the dispute, you're going to be wasting your time. And I have to admit, I've been in those situations where I've tried to warn the parties and their counsel to come to the mediation prepared, ask for mediation statements to help them get prepared. And they've taken certain steps, but missed many others. And if I could point out probably the biggest mistake in terms of not preparing for a mediation is for counsel not to prepare its client for what a mediation is and what is intended to happen in a mediation. I can't tell you how many times people have come in and thought I was the judge and tell me the story as if I am deciding their fate, as if I'm making the ruling. I'm a neutral. I've got no decision making in a mediation. And if they come in thinking I do and I don't, there's a lot of anxiety and sometimes anger about the process that they were never prepared for. And again, things can go off rail pretty quick.
Mm-hmm. Right. And commercial mediation is different, a lot of times. And if we just set the stage for like what to expect in that, typically we're having the clients or the business owner and their lawyer come in for both sides, right? So the mediator is typically doing like a caucus style. So going back and forth, we facilitate it on Zoom in rooms, or you do it in person in rooms, right? Now, what I have counseled, because of course I'm on the business valuation side, and a lot of times a commercial litigation or a commercial mediation is going to govern, like a contract issue, a dispute about payment, some sort of, you're buying out a partner and what is the value that you're buying them out. A lot of times what I'm saying to them is, instead of making this so robust and creating like a position statement or a mediator position that's like 10 pages long, right? I'm encouraging them to come up with a 1 or 2 page. And they're like, I can't put this in 1 or 2 pages. I was like, yes, but if you try, you're going to get very, very clear on what you want. And what, if I say you only get 3 issues and you have 10 issues, I want you to start to identify the really big issues. So, and even sometimes like a big valuation report could be like 50 to 100 pages. Yeah. What if we just had a summary? What if we just showed them the revenue and the profitability and the value over time? Like, what if it's really simple in order to convey your message more clearly? And a lot of times we're telling them that you're telling a story to the mediator, right? Yeah. So do they care about everything about your story? Probably not. Probably not. Right.
The simpler, the better for everybody, including the parties involved, and educating the other side of the table about the issues. If you throw down this 100-page report, certainly some that they've never seen before at the mediation, nothing's going to happen. No one's going to be able to pour through the report at the mediation to resolve the matter. But I want to go back to sort of what you're talking about valuation, which is a fundamental aspect of mediation and a hard truth about mediation. No matter what the dispute is, including personal injury, wrongful death, divorce, anything, even as emotional as you can get, so many of the issues ultimately are decided only with money, right? And that's a hard pill to swallow sometimes when you're thinking about the fact someone has put their life into a business and a business partner allegedly did something wrong, or in a marriage, or a contract breach that has resulted in the loss of business. Those are emotional things. But the only way we can remedy these in our system is money and a calculation of money. So having a simplified valuation as part of that discussion is so essential. And it may feel outside of the realm of what going back to the psychology of what people are trying to do in this mediation about being proven right or wrong. it comes down to a negotiation of dollars. And that, I know, again, it seems crass sometimes that it's only about the money, but they are tied together: valuation, money, resolution, settlement, as part of this process.
Mm-hmm. And I think some of the psychology that we see in mediation that I see a lot from the business side is, you know, entering into this process thinking that whoever wronged you is going to make it right via money and via an apology or via a public proclamation, or, you know, because a lot of times, you know, that we get to these impasses and they'll be like, well, I'm not willing to negotiate any further because they hurt me, because, you know, they affected my like they did this on Christmas Day and it affected my family and I can't forgive them for that. Like, where are you seeing that emotion create an impasse, or how are you getting through it?
No, this is exactly the stress point of why mediations are not simple. They take a lot of time and energy to be successful. And for the most part is because of the headline of this podcast is the psychology involved with people's emotions and positions and attitudes as they walk into the room. I think it's all about psychology. And I wish I had finished my undergraduate degree in psychology as compared to going poli-sci, because when I took those psychology classes, learning about how people see the world is really important in a mediation. So someone comes into a mediation, there's a lawsuit pending or some dispute for which they're on opposite sides. Somebody thinks they're right, somebody thinks they're wrong, right? It's bridging that in a few hours is really hard. The psychology part is maybe sometimes working outside that, recognizing how a person will feel if this dispute is resolved, if there is closure out there, if money is given so that the family can move on or the business can go on, that they are not anchored down in a dispute that is costing the business money, maybe damaging the business's reputation. There's so much other psychology that goes into a good mediation. And the more a mediator knows about those issues in advance of the mediation, the better the mediator can be in helping the parties reach those goals. I think the word closure for me is, in the concept of closure, is something that I use a lot in my mediations, because I see a lot of personal distress by parties, even CEOs of large companies that are involved in these litigation matters. They want this to be over. They don't want this weighing on their brains. They don't want this weighing on their P&Ls. They want this to be over. They want closure. How do they get closure? You sit at the table, you work with the other side, you let the mask of positioning soften, and you reach closure.
Mm-hmm. Well, and you have kind of two places that I think offer some insight into the psychology, because what I will see, regardless of the mediation, is that it does take time. Like, a lot of times we're not just seeing one mediation resolve things. It's almost like people start to commit to, we're going to go back to mediation and work through these issues until we resolve it, right? In some capacity. But a lot of times when they get to, okay, there's an offer and it's still not perfect, but it's enough for me to say yes, they go through this mental machination of, well, but I've spent a couple $100,000, so I need to make that back, so as they go through the negotiations or the mediation, the number of the request or the ask continues to go up because you're incurring costs. And so at some point, like, I had a client recently that's like, well, I don't even know it. I have so much money invested in this, I might as well just go to trial.
Well, let me answer that part, because there's two elements to that. One is, it is a strong movement in our industry now to have pre-litigation mediation. So before you start spending money on filing complaints and doing discovery, you know that there's a dispute, have people sit in a room and communicate to see if it can be resolved. It may not be, it may be too early, but if these are business partners or domestic situation that, everyone knows what's on the table and they just haven't talked and they haven't had someone to facilitate those discussions, it's very possible that before you start churning up attorney's fees, which is that cost, that other line item that you're talking about right now, which is almost making the case unsettleable because of the attorney's fees involved, you've taken care of that issue. So let me talk the other side. This belief in the recovery of attorney's fees. The courts are not very patient about awarding attorney's fees in commercial matters. It's a cost of doing business. There certainly, if there's a contractual provision that clarifies prevailing party will get attorney's fees, then I can understand why a lawyer is sort of adamant that they have the right to seek attorney's fees. But absent a contractual provision to allow them to recover attorney's fees, when they're seeking what is in Georgia a bad faith attorney's fees claim, 13-611, for the behavior of the other side based upon the dispute, it is very hard to recover those fees. So putting them on the table as part of the calculation of the resolution of the dispute, I think is a mistake. I think it's a presumption that hampers the ability for cases to settle. And I think that counsel who argues for the full recovery of their attorney's fees in a mediation can do that all day long. Case won't settle. And then they better hope a judge awards attorney's fees at trial, or they're going to be embarrassed that they represented to their client that was expected.
Mm-hmm. Well, and
you can tell I'm fired up about this. I mean, these are topics that, Melissa, you live with this every day too. I mean, you really want to shake people and say you can either resolve your disputes in mediation or alternative dispute approach, or have at it at the courts. The court dockets these days are years long. The motion practice, I'm still an advocate in cases. We don't get rulings on motions for months and months and months, and it costs thousands and thousands of dollars. Look, as a lawyer, that's how I made a living for right now, 39 years. But I'm also willing to give that up to ultimately now help people resolve their disputes without having to give up their life savings and their business revenue to lawyers.
Mm-hmm. Well, and you're bringing up several good points about, as a business owner, if I have some partner issues, right, I can either sit there and let them fester and it's going to get worse, and then we're going to get to the point where everything blows up, or I can really and see how you're going to change this a little bit of how I say it. But in my mind, two business partners would come to a mediator that understands business law, could be a business lawyer, whatever, somebody like you that understands the court ceilings on damages, what the court is going to do. So a lot of times the business owners are dealing with this issue as a business owner, be like, well, this needs to be fair, and what about this, and you didn't take that into account. As opposed to when they're coming to you, they would be like, okay, well, how would the court system handle this? What are the limitations of the court system? Well, the court's only going to look at this contract for 3 years. You're not going to get damages for over 3 years, something like that. Right. To me, it could educate these two that it's not about going to court and I'm going to get millions. It's about, let's get this resolution so it's confidential, so that we're not airing our dirty laundry, so that, we can come to a reasonable position and see each other's perspectives. And so in my mind, it's a really good business strategy to have maybe a mediator, we used to keep lawyers on deck. What if we had a mediator on deck that we could be like, yeah.
Well, you bring up some really interesting points. One is the role of a mediator to help the parties understand the possibilities of their case is generally considered to be an evaluative mediator. And I am an evaluative mediator. I can't help myself because of my years of practice. In fact, I don't want to take this away from younger lawyers who are also mediators, but I'd like to think my experience in the courtroom and representing clients for almost 40 years has a benefit as a mediator to assist in the evaluative nature of the parties' cases. I cannot tell them what will happen. I can tell them what I've seen happen. And I can tell you, this is why retired judges are sometimes the most successful mediators that are out there, because this was their life. I mean, they sat and they listened to arguments that worked or didn't work, and they can share some of those stories. So I do think that's important. In terms of your comment about having a mediator on retainer as compared to having lawyers on retainer is not that far-fetched. I've been working in the construction field on the use of what's called dispute resolution boards, where the construction matter that's being built, the infrastructure project or large commercial project is being built, and they have a team prepared to handle any disputes that come up during the project, to resolve them as they happen, on disputes between contractors and subcontractors, or between vendors and contractors, between the owner and the general contractor on change orders. You literally sit sort of on call to handle these things. And then instead of letting these fester, exactly what you said, until the end of the project, where then all things go to hell, and projects are delayed, and there's money held back, whatever. They have these immediacy resolution strategies with these so-called dispute resolution boards. I think it's a great idea, and I think it's money well spent.
Yeah. And I think that I am seeing mediation, because what you said is correct. Like, we have a lot of mediators that are coming in that are younger and that have less experience. And I've talked about this a lot. Like, you probably don't know business valuation until you've done it for 10 years, right? You probably don't know mediation until you've done it for probably 5 years on a consistent basis. And so in my mind, mediation and mediators are going to move towards being more specialized, right? Like, I really focus on mediating business valuation issues, right? If there's a business valuation that's going to determine how we're going to do this, I pull two parties together. I help, and I am offering, like, this is a little bit different than mediation, is that I'm acting as if I'm a joint valuation expert, but I'm employing mediation tactics to get the parties to agree to the underlying assumptions of the value. And then I sort of expose, oh, look, you guys agreed to the structure. You agreed to the foundation. You agreed that the walls would be stucco. You agreed that the ceiling was going to be tin. You agreed to all these things. Now, look, here's what it means to you. And everybody has to be like, ugh, well, I hoped it would be higher. I hoped it would be lower, but I guess that's reasonable. So in my mind, if you have a business issue or a business dispute, you're not going to a divorce mediator. You're not going to a employee, employer kind of mediator. The mediator should be knowledgeable about the court system, about the specificity, because right now mediators are just mediators. Do you see people moving towards like the specialization?
Absolutely. I mean, it's one of the reasons I joined with Miles Mediation here in Atlanta, is because they were developing these subspecialty groups exactly for that purpose. There was one phase where companies like Miles were just doing personal injury resolution, but they realized that there was a need for commercial and construction and employment. And this is true around the country, I'm sure, with mediation groups, that subspecialty that they could bring in people that could be truly evaluative to help the parties is a real value. So, and I think it is a natural evolution. I will tell you, and I've said this to you because I know you do domestic work. I don't have the structure to be a domestic mediator. I'd want to give everybody everything. I mean, and God, having like a custody case, I'd be melting. So, I mean, but there's people that really understand it. are well trained in it, those are the people that should be in the room doing family mediation and domestic work.
Well, and I think a misnomer for about the money issues, which a lot of domestic, the reason, we're dealing with money or kids, right?
Yep.
For the most part, the money issues that we see are like, would it surprise you if there's really only maybe 2 or 3 valid ways to split things from a monetary standpoint? Like, would that surprise you? Because I think it surprises a lot of people that there aren't unlimited, like everybody's like, well, there's so many options. There are, like, money just has a few different options, right? Even with a valuation, you have a higher range, you have a lower range, and then there's this reasonable range of value. In my mind, mediation is not about getting very specific. It's getting very open to a range of opportunities, but understanding that those opportunities could be limited, right? So it's not, there's a million ways to split a building. There isn't, right? One of you keeps it, the other keeps it, or you sell it. Those are 3 options. There aren't 5 or 10 or 20. Now, again,
or they can live together at like War of the Roses. So,
right.
There's always something else. Yeah.
Right. So I think
I think one thing you said earlier, though, about the multiple ways of sort of skinning the cat to whether it's money or something else, is you mentioned apologies. You mentioned other actions that could be creative solutions to a settlement and a mediation. And I have used that as well. I've been in a situation relatively recently where a dispute evolved between a contractor and a vendor over the product and the alleged defect of the product and the cancellation of the order and all the complications and the consequential damages that came out of that. One of the resolutions was the settlement of that specific account, but an agreement to place that vendor back on the approved list. And this contractor has multiple projects going forward where they're going to need that vendor to help. So it was this shaking hands. We know this didn't go right, but we trust each other again. We're going to use you again. And let me tell you, for that vendor having those projects in the pipeline, that had value. It wasn't real dollars at the time. It was the acknowledgement that the relationship had been cured between the parties, and that went a long way. I mean, just as to me, and actually I write about this in the book. In addition to one of my chapters being the psychology of mediation, and I just thought that it was great that you used one of my chapters to title the podcast. But the other one is using creative solutions in a mediation, being open to it, not just being about money, but listening to the parties, understanding what they need to get this matter resolved. And then when the time is right, taking what you've learned and trying to use it for the purpose of helping the parties reach a resolution.
Mm-hmm. Well, and to me, mediation is the ultimate playground for negotiation. Like, as a business owner, if you can get prepped, and a lot of times we're not even presenting the actual valuation. We're presenting a different approach in mediation. Like, we're presenting the market approach in mediation, but doing all the approaches for, so we're protecting our position for litigation, but also operating in mediation. Now, one psychology that I think you will also agree with is at the end. And this happens with mergers and acquisitions. This happens when we get close to closing a deal. This happens when we get close to agreeing on a resolution, because the resolution is not going to be a super win-win for everyone. It's going to be okay, it's good enough, right? And so when we get close to the end, even in divorce, even if they hate each other, there is.
I know what you're going to say. I know what you're going to say. Go ahead.
You get to the end and there's this almost like, we now have to face that this thing that we wanted is done, right? Like, we're going to walk away and we're not going to be on this drama train. We're not going to be thinking about this every single day. And there is literally, I will see people back up from the deal when we get so close to being done that it's almost like, well, am I getting screwed? Well, is this good enough? Well, should I ask for something more? Well, but it's done. But and it's almost like they were addicted to some of the drama and the trauma that it's almost hard to say we're done. Like, how do you see that psychology at the end?
Again, I'm a big advocate of closure. That the adrenaline that comes from being in a dispute is real, and you're absolutely right that a lot of people, um, as crazy as this sounds, sometimes I've been in situations where the only thing a party wants is this case, like to prove the principle of this. And no matter what you do, even if you completely admit everything and even almost offer everything, they won't be satisfied. Those cases can't be settled. People, and I think we were talking about this earlier about the concept of logic, especially in business context, is the logic of a business owner is to resolve a dispute relative to the dollars involved and some other ancillary business issues that might apply, the confidentiality that you talked about, maybe non-disparagement provisions between the parties, what they say to the press or what they don't say to the press, the other little issues that may come in. But if you have a party that their life is destined to attack this company, I don't care how good of a mediator you are, cases are going to be settled. I also thought about the fact that sometimes you have to be the big boy in the room and make the parties shake hands when it's over. I mean, and sometimes not. Sometimes everyone kind of packs up and leaves and just ends the day. They've signed their agreement. We don't need to see the other side. But sometimes a handshake, a mature act of confirmation of resolution between businesses and sort of the positivity of moving on professionally is very important. It doesn't always happen, but sometimes that it's a good feeling.
No, and I think that when we're actually in this process, because I have the benefit of being in a lot of different mediations as a financial expert. Like, I'm doing a business valuation for a commercial mediation. So I get to witness a lot of other mediators' skills, tactics, solution finding, process. Some I like, some I don't like, whatever. But we had a recent one where I asked them one simple question at the beginning, and I asked my people, who is in the other room? Are they the decision maker, right? Because we have a board. They were saying any offer they had to take back to the board, or they had to get approval, and all of this stuff. And I was like, who is in the room? Who is it? Do we have a decision maker in the room, or are we playing a relay game? And this was a case where we came to a solution at the end. We agreed to it. And guess what? A week later, they're like, nah, we can't do it. So, and I know that there's a lot of mediators that do different things at the end when you've reached an agreement, but could we have done anything different? And I can tell you other things that happen. I'm kind of telling you one vignette of it, but like, could we have done something different? Like, you as the mediator, would you have done something different to try to lock in the parties to this agreement? Or let's talk about how mediation is not necessarily always about the capability of locking somebody in. Like, what would you have suggested?
I wish I had the power of the court or a judge to require that everyone in the room has the ultimate authority to settle the case when they're there that day. There are certain instances where where insurance companies need to be involved. They give certain authority at the beginning of the case. The settlement requires approval for separate authority that they can't reach the manager, they can't reach whoever they need to reach. And there's a lot of frustration that, hey, we thought we had the people that could make the decision. It turns out that they don't. But I try not to let the whole thing blow up if that's the case. there's many times that I'll suspend a mediation based upon where the parties sit, freeze them in their positions, await impact from the adjuster or bank who may be making a loan. I mean, there's a million different ancillary elements sometimes that do factor into these commercial resolutions and or personal injury ones with insurance, or insurance even factors in with commercial if you're dealing with property damage or losses. So it happens. I try to motivate people to do it. I can't do anything about it if they don't. I can't sanction them. I can't charge them for that time. So the one thing I can say is, and I've never had this happen in my experience as a mediator, but if you have folks that come to the mediation that truly are there not to participate, that are truly acting in bad faith, maybe only meeting the physical requirement of being at the mediation but don't participate, I think there's a chance that I would report to the judge the failure to participate in good faith, if I really felt like it was being used as a charade to frustrate the other side, or they misrepresented certain things to me. Anyway, long story short, I know it happens. I try to take a positive view when it does happen. Hey, let's just take a break. We'll reconvene, let them talk to whoever they have to talk to. The world wasn't going to change anyway based upon that particular date. It's very unlikely that mediations happen the day before a trial. I mean, trial's still on the calendar. We have time to talk. It's the benefit of Zoom and reconnecting with people, even if they go back to their offices in other cities.
Right. Well, and I think that when we're typically looking at mediating, a financial issue, I think that this is where it becomes interesting, because mediation is both of you coming at will, right? You're both endeavoring to negotiate this, and you kind of have a referee that sits in the room and gives you some basis, because everybody goes down this path. Well, I know I'm going to get that. The court's going to give me that. Well, maybe that's not really true, right? Like, so you have somebody that's giving you, right, no guarantees at all. So then, to me, and the reason why I wrote the book Anchor the Deal, is I think that you have control over how you present and how you prep for the mediation. So if you can't control them to agree to you, how do you make a compelling offer? How do you start to see what the other side wants, what you believe happened? Like, how do you start to create a position that the mediator will be like, that makes a lot of sense. Let me go see if the other side could agree. Like, you're being reasonable. That makes sense. Well, how did you get, like, and it can't just be like, well, I think the business is 5 million and they should just take it at that. No, how did you get there? How did you layer it up? How do you prove your position with outside data points that somebody could come into? Like, when we're valuing a business and we're going in mediation, we might produce a bunch of market data, right? People can understand that. Oh, that business sold for that. Oh, here's the market. Oh, here's the multiples. Do you argue with that? Like, how do you kind of position it? Because mediation can be your tool if you're more prepared, because a lot of people do not prepare for mediation, right? So now you're prepared, they're not. Where do you see, does the unprepared party prevent us from settling?
It's a great point. I mean, again, goes back to something we talked about earlier, is that preparation is a key to coming up with a fair resolution that both sides are comfortable with. If a side's not prepared and they don't know what to be looking at, and an offer is made, I don't know how they're supposed to evaluate it to see if it's a fair number. But I will say that in the context of making offers and counter offers, I'm not surprised anymore when the first offer is astronomical and the responsive offer, counter offer, is also astronomical, low compared. I mean, and the gap between those original numbers makes everybody go, this is not going to settle today. I think it's the personalities of the players sometimes that they have to start at their demand positions and then work from there. And I don't really have a problem with it. It'd be great if everybody started at half of what they demanded to move the mediation faster. But in my experience, it takes a lot of time. People want to tell their stories. A lot of evidence has to be discussed. And then at some point, the numbers will move because people start to realize why they're there. That it may be after lunch and they're getting tired and they go, oh gosh, I have, a few hours left and this is my one chance to settle the case. Better now to start really talking about the case. I will add that maybe a solution to a lot of this is something called the mediator's proposal. And I have used that in many instances where the parties are not moving the way they should, and it's coming to the late in the day, and the parties are motivated to settle, and they look to the mediator and go, what do you think? And you can present that proposal without any binding elements to both sides. One may take it, the other may not. But it is a strategy to assist parties in resolving their cases by using this proposal. And I've seen it work. I've seen it work that I've used it. I've also seen it work when it's been given to me, because it's that one flash where the mediator, who you hired in the first place because of their experience and evaluative support for the case, says to you, this is what I think the case should settle for. And you better be right if you're going to ignore that recommendation.
Mm-hmm. Well, and I see mediator proposals more often in commercial mediation, and I see it less often in divorce mediation for whatever reason. Maybe there's just a lot of moving pieces. I would say in business valuation, when we're working together with the business valuation, we are offering a value, right, that I'm saying would be kind of like my proposal, but we're also saying, hey, here's the couple areas you guys disagreed on. So it makes it a little bit higher and a little bit lower. And the reality is, if people started to negotiate based on a reality, a real number, a supportable number, we wouldn't be at those sky high, I go high, you go low, let's continue to eek until the mediator has to give us a proposal and then we agree to it. But what else I think is something that you think a business owner would know, or we can talk about how they can reach out to you if they have business. Now, here's something that people may not know. Like, could you work with people outside of Georgia?
Oh, yeah. So, in fact, there's some mediators that aren't lawyers at all. So we're not governed as a mediator to the state bar rules of being limited to the jurisdiction of our state to appear. In fact, I just did a mediation where the parties were out of state, but came to me based upon my knowledge in a particular area of construction. So, the beauty of being, look, there's national mediators everywhere. I'd be honored to work with people who just need a mediator. And these days, not that I wouldn't love to travel to wherever people need me, but I mean, we do a lot of virtual mediations with parties all around the country. I want to just sort of finish one thought that I think comes full circle with the psychology of what you've talked about today. And this has been really fun, Melissa. I think it's really interesting to get your perspective as a valuation expert too, when you're talking about mediations. Is what is success in mediation? Like, people are really triggered. A lot of us are wired that you're either going to win, you're going to lose, or you have to be successful or not successful. Your day has been a good day or a bad day. In mediation, you have to really be willing to give yourself a break as to what success is, because success ultimately of resolving a dispute that's been on your plate for years, costing lots of money, a lot of uncertainty, a lot of strife, just getting it resolved, even if it's not for what you hoped you were going to get, or you're paying more than you expected to pay, I believe is success. And I think that if people feel comfortable changing their definition of success sometimes in a mediation context, you're going to have a lot of, I hate to use the word happy people, but maybe relieved people leaving the room when they're done.
Mm-hmm. Well, and I think that success for me in mediation, or what I counsel, people on, is go into mediation not expecting to settle. Go into mediation being willing to be open to options, being open to gaining information, gaining knowledge about the other person, the other side's perspective, understanding their position. In some respects, understanding what part of their position is ridiculous and what's going to falter. And like, it's almost like trial prep. You're gonna learn a lot of information in mediation. So if at a minimum, if that's all that the result is, you get a little bit closer. You can maybe continue the discussion. Maybe it breaks up that you weren't even talking, right? Maybe it just is a icebreaker that's like, okay, maybe we can handle this a little bit better. But you are going to gain something out of it. And then if it's a deal that is decent enough for both of you, you will settle. Like it's not going to be like, well, I have no other options. And if I don't do this, I'm going to get screwed in litigation. You can't think like that, because then you're negotiating under a little bit of duress and not thinking about what you want. I tend to tell people to think about what you want out of this mediation. Focus on what would be best for you, not a win, but at least, reasonable. And I think that that's really, really good to know that success in mediation is not settling always. It's a lot of other things, right? And that one mediation may not finish it. You
Yeah.
may need, like the first mediation is a great starter. Hope that the second mediation, for sure, then everybody comes a little bit more prepared. Then everybody's like, oh, this is what this is entailing. Oh, okay. Yeah, I should have brought the documents, or I should have been ready for this. We didn't talk about it. So, any parting last remarks, and we'll kind of add, like, how can people reach out to you? What do you think that people should take away from this as a business owner? Um,
Well, first of all, again, I appreciate the time. It's been a fun conversation. I mean, the topic of mediation for some folks may be sort of something they don't want to talk about, but I think in the nature of our world, and the concept of creating peace, whether it's geopolitical or just your business, you have to be willing to sit in a room and try to resolve your differences, and be willing to listen and reach a resolution. I can tell you that the folks that I work with that resolve their cases are much better off than the ones that are still in litigation. I think that's true. I think you could agree with that. So look, we've taught them a little bit about mediation today. Maybe it's front of mind for the next folks that start going down the path of dispute to try mediation. I'd consider that a win, just so that they learn about what mediation is.
Absolutely. And if people want more information about your book, The Mediation Minute and Insights, I became a mediator about 10 years ago because I had been in litigation for 20 years. And I was like, I think that this is the wave of the future. Like, had no idea that AI would come in and all of these other things that have changed the trajectory of litigation forever. But to me, not all mediators are the same. And so I think the takeaway from this is, if you have, especially around money, and even further, I will tell you, the valuation issues around construction companies are vastly more complex, and their financial structure and how they, account for costs and account, like all of these things, if you've never done a construction company, are things that would be unfamiliar to somebody. So the days of hiring a mediator because they're a former judge, or there's some, like they were good at something, that is one basis to hire a mediator. The other is, if it involves money, you need to hire a mediator that understands the money in your situation, the intersection of legal, of money, of settlement, of negotiation. And for businesses, that means that you probably have to work with a mediator that has more experience, a depth, like a level of depth in that certain area. And then you're really going to somebody that's not just a referee sitting in the room and be like, oh, be nice. Don't talk like, like that's not what mediation is about. Mediation is really about giving you insight into how your perspective is one perspective, right? And so I think going forward, if you had a construction issue, I would definitely reach out to Scott. Like these are nuanced issues that you want somebody to know the playing field. You don't want to educate the mediator on this and they'll be like, oh, wow, billing in excess of costs? What does that mean? Right? No. You don't want that situation. So I appreciate you, Scott. You have a lot of good information. If you want to come back and talk more about commercial mediation, I'm always welcoming you back.
Thank you. Thanks again for having me. Really good program. Thanks everyone for listening.
All right. We'll see you soon.